please stand up and welcome the President and CEO of the National Constitution Center, Mr. Jeff Rosen!
Thank you very much. Hello, students of Louisville. I am excited to be here and to issue you a meaningful, important challenge. And that challenge is to educate yourself about the U.S. Constitution and to connect with other classrooms in your community or across the state or even across the country for hard constitutional conversations about the issues at the center of American life, like the First Amendment right of free speech or the Second Amendment right to bear arms. Now, why is it so crucially important that you educate yourself about the Constitution and that you organize these conversations? It's because they very much affect your lives. All you have to do is read the news to see how almost every issue that's coming before American life involves the Constitution. So just 2 days ago, the U.S. Supreme Court held that if the police arrest someone for selling $522 worth of drugs and they fine him $1,200, it's not fair for the government to seize his Land Rover, which cost $42,000. That's an excessive fine, which is prohibited by the 7th Amendment to the Constitution, and it was disproportionate. So that's a huge principle of liberty that says that the government, if you do something small that's wrong, can't take away something that's really big. Take the biggest issue in American politics right now. Can the president issue an emergency declaration to build the wall? Well, that's, okay. What I'm going to challenge you to do when we have these conversations is to separate your political views from your constitutional views. In other words, this is important. This is very important that you listen to what I'm saying. You might think it's a terrible idea for the president to build the wall. It's unfair and it's really bad policy, but nevertheless, the Constitution and the laws allow him to do it. Or you might think the opposite, that it's a great idea to build the wall, and it'll really help America, but the Constitution or the laws forbid it. And what I want to tell you, we can have a discussion about the wall. I just had a hour-long discussion about it yesterday. It is a hard legal question. There are good arguments on both sides about whether or not the Constitution and this law that Congress passed in 1976, which gives the president huge power to declare whatever he says is a national emergency and to move money around whenever he says the military requires it. That's what Congress did in 1976, and there's an argument that he's allowed to do it. But I don't want to talk about the wall right now. I want to talk about an issue that very much affects your lives and just came out of Kentucky. And the U.S. Supreme Court just reviewed it and decided not to weigh in right now. This is a law passed by Kentucky that allows any school administrator to punish as a misdemeanor any student who disrupts or interferes with normal school activities. That's the law. If you disrupt or interfere with normal school activities, you can be charged with a misdemeanor and fined up to $500. And in fact, there was a student here in Kentucky who was passing out leaflets. And his principal didn't like the way that he was doing it, and he said, stop passing out those leaflets. And the guy objected. He got a little hot, and he said, he used a curse word, and he said, let's take it outside. I'm going to lick you, and so forth. And the teacher prosecuted him, and he got fined $500. And he said, that violates my First Amendment rights. And it went up to the Kentucky courts, and they disagreed. They said, no, you're allowed to do it because schools can enforce discipline. Now, as it turns out, 22 states have passed laws like this, and a bunch of other courts have struck those laws down, including in Arizona and North Carolina. So there's a real hard question that we have to talk about right now about whether or not it violates the First Amendment for states to pass laws that allow your teachers and your administrators to discipline you if they think your conduct interferes with or disrupts normal school activities. Now, what I want to do is have a constitutional conversation with you about this topic. And that means first we're going to set aside our political from our constitutional views. I don't want to know whether you think it's a good idea for the administrator to punish you if you are passing out the leaflets, although I think I have a decent idea about where you might fall in that question. I want you to ask, does the First Amendment allow it or prohibit it? And open up the possibility that you might think it's a terrible law, but teachers are allowed to do it, or it's a really good law, but the First Amendment prohibits it. So to answer, what I want to do is first take a vote about whether you think the First Amendment is violated. Then I'll tell you a little bit about what the Supreme Court has said about the First Amendment and what the relevant cases are, and then we'll vote again to see if you've changed your mind. All right, so to have a constitutional conversation, we have to start with the text. We can't talk about the First Amendment unless we know what it says. So I'm going to take out the text of the First Amendment. You can do it, of course. This is my job. I'm a Constitution geek. I carry a Constitution with me at all times because I work for a really inspiring place called the National Constitution Center in Philadelphia. It's the most extraordinary center for constitutional education in America. It's right across from Independence Hall, where both the Declaration of Independence and the Constitution were written. Has anyone heard or seen the musical Hamilton? Yes. Well, that's the room where it happened. Independence Hall is the place where the Constitution was written. And every day I get to look out across in the best view in America on Independence Hall and just be so inspired by all the light that flowed through those people who wrote the Constitution. And then the mission of the Constitution Center is to increase awareness and understanding of the Constitution among the American people. So that's why my challenge is very important, because unless you can figure out a way of connecting with other classrooms and having these important constitutional conversations, we won't be able to spread all this constitutional light. So the time we have is precious. All right, so let's begin with the text. I could open up here, or you can download this phenomenal app that the Constitution Center has just launched. It's called the Interactive Constitution, and I want you all to download it. Not now, because I am talking, but after the challenge, you can download the Interactive Constitution, and you will find the text of every part of the Constitution, as well as the best liberal and conservative thinkers in America who are writing about what they agree and disagree about every clause of the Constitution. It's really important when you have these conversations that you listen to views on different sides, because just like Supreme Court justices, people can disagree about what the Constitution means, and it's all online. So we're going to read what the First Amendment says. Congress shall make no law abridging the freedom of speech or of the press. Congress shall make no law abridging the freedom of speech or of the press. It doesn't say Snapchat shall make no law, or Facebook shall make no law. It doesn't say that private schools are not allowed to make any law. It says Congress shall make no law, and the Supreme Court has interpreted Congress to mean any public institution. So public schools are covered by the First Amendment, and the question is, can the Kentucky legislature, which is also a government institution, make a law abridging freedom of speech? So the question we're talking about is, does that law, which prohibits any speech that interferes with or disrupts normal school activity, is that a law abridging the freedom of speech? So let's take a preliminary vote. Who thinks, based on just the text of the Constitution, that that Kentucky law violates the First Amendment? And who thinks it does not violate the First Amendment? Okay, there's about two-thirds, one-third. Who's undecided? Great. It's great to be undecided, because we haven't even started to talk about this. We don't know about the history of the First Amendment or what the Supreme Court has said or other considerations. All right, so as quickly as possible, let me try to review the major history and precedents that are relevant to this case. When the First Amendment was drafted, the big concern was criticizing the king. Congress was passing these laws that forbade criticism of the president. In fact, in 1798, there was a law prohibiting criticism of the Federalist President John Adams, but not of the Republican Vice President Thomas Jefferson. That's how skewed things were. And that was called a sedition law. And a lot of those laws were upheld for a long time. But then it was 1917 and it's World War I. And people are standing up criticizing the war. And a guy called Eugene Debs gets up on a street corner and gives a speech saying, "Don't go enlist in World War I. This is a war that's being fought for the capitalists." And he goes to jail. The Supreme Court upholds his conviction. He runs for president in 1920 from a jail cell merely for making a speech criticizing World War I. But in a series of path-breaking dissenting opinions, in this period, the Supreme Court begins to formulate why it's crucially important to protect free speech. And the reason I'm so excited to be in Louisville, I have to share with you, I love Louisville, I was really psyched to hear about you guys, but the greatest Supreme Court justice of all times when it comes to free speech was from Louisville. Who is that? Brandeis, Louis Brandeis. You have no idea how lucky you are to be in the birthplace of this giant of American jurisprudence, this prophet of free speech and privacy. I passed by his house, it's 310 Broadway, and I paid homage to it because there is no one in the 20th century who better articulated why it is important to protect free speech. And here is what Louis Brandeis said in a case called Whitney versus California, where he is objecting to the fact that the Supreme Court upheld the conviction of a woman who stood up and criticized anti-lynching laws. This is a woman who's denouncing racism, and she says that it is wrong to engage in this racist violence, and she's charged with being a communist because she makes her speech at a meeting where there are other people who call themselves socialists. The Supreme Court upholds that conviction, and Brandeis objects in the most incredible words ever written about free speech in the 20th century. I think I can recite them from memory because I'm such a Brandeis geek, and I've done this once or twice before. Let's see how I do. But this is from the Whitney versus California case, and what's so amazing is Brandeis begins by talking not about Hamilton and Madison and the Constitution framers of 1787, but of Thomas Jefferson and the revolutionaries of 1776. This is Brandeis and Whitney. Listen carefully to his words because he's telling us why we need to protect speech. He says, "Those who made our revolution believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty." That's from Pericles' funeral oration. They believed that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth, that without free speech and assembly, discussion would be futile, that with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, that the greatest threat to freedom is an inert people, that public discussion is a political duty, and that this shall be a fundamental principle of the American government. In those amazing words, you understand why Brandeis produced the principle that the Supreme Court came to embrace in 1969, namely that speech can only be banned in America if it's intended to and likely to cause imminent violence. Direct incitement, go shoot Jeff now, he's talking for too long. That would and that should absolutely be banned. Don't say that. But short of a credible threat that's likely to result in imminent violence, Brandeis says, discussion is ordinarily the best remedy to evil counsels. Hate speech should be answered by good speech because of Brandeis's incredible faith in us, we the people, as citizens, and in our reason. Remember, he said our goal is to cultivate our faculties of reason, and Brandeis says as long as there's time enough for deliberation, then reason rather than passion can prevail. So there in that incredible passage is the whole American theory of free speech, and now you understand why America protects more free speech than any other country in the world. And in America, generally, hate speech is protected by the First Amendment. Obviously, no one likes hate speech. It's the most hurtful, offensive speech imaginable. But unless the speech is intended to and likely to cause imminent violence, the American tradition says, counter the hate speech, denounce the racist, have deliberation so that good counsels can prevail over bad ones. All right, that's the core principle of free speech. So if, based on that, you'd think, hey, speech that might disrupt or interfere with normal school activities, that doesn't sound like it meets the test. That's not intended to and likely to cause imminent violence. The guy talking back to the principal because he was passing out the leaflets sounds like it's not even a close case. But schools are different. The Supreme Court said in another case in 1969 called Tinker versus Des Moines that it's not great. Good work. You knew it. What did the case involve? Do you remember what? Yeah.
Black armbands protesting Vietnam War between pair siblings in school sought to limit their expression in that case.
Beautiful. Not everyone can hear. It was a perfect statement of the facts. Black armbands protesting the Vietnam War, a pair of siblings, one was Mary Beth Tinker. The school sought to suppress the expression. Mary Beth Tinker says, I'm protesting the Vietnam War. I'm giving a peaceful protest. I just am wearing a black armband. The school says, you're disrupting normal school activities. You're being disruptive. It's basically a version of the Kentucky case. The Supreme Court, in a beautiful decision, said, constitutional rights do not stop at the schoolhouse gates. You do not lose all your constitutional rights because you are students. However, schools are special environments, there are special safety considerations, and therefore speech that substantially interferes with school disciplinary proceedings can be restricted. That's a different standard than intended to and likely to cause imminent violence, but it sounds like a much more restrictive standard than any speech that might interfere with or disrupt ordinary school activities. We're parsing words here carefully. Words matter. They matter so much. It's so important to read the text and to really parse those legal standards. But just talking very quickly, I've just given you a lot of what you need to know to make an informed vote about this. You know the text of the First Amendment, you know Brandeis's theory about what kind of speech is ordinarily protected, you know what the Supreme Court has said about speech in public schools, and you know what the Kentucky law is. All right, let's have an argument for and against whether the Kentucky law is constitutional. Who, based on what you've heard, thinks that the Kentucky law violates the First Amendment? And who, based on what you've heard, thinks the Kentucky law does not violate the First Amendment? Okay, wonderful. Let us hear, I just want to hear an argument on both sides. You said it does not violate the First Amendment?
Yes.
Tell us why you think it does not violate the First Amendment. Sorry, I'm a law professor, so I call on people, and sorry not to warn you. What? Absolutely. Go GW, totally.
All right, I'm Elijah from Eastern yet again, but I don't think that it does violate the Constitution because cases set precedents such as Tinker Des Moines. You kind of do give up some of your right when you enter a school in order to create a teaching environment, and teachers imposing on that, such as assigning discipline. Like, discipline is something that they should be allowed to do in order to ensure that their teaching environment is not disrupted, and therefore it should be constitutional. And I believe that would be upheld by the Constitution.
Excellent. Very well stated, very crisply stated. You just said we have fewer rights in school than outside of it. Schools do have the right to enforce discipline, as Tinker said, and therefore this Kentucky law, which prohibits disruption of the school environment, although the words may be a little bit different, basically sounds like the Tinker test, and therefore you think that courts would uphold it. And indeed, the Kentucky court just did exactly that. All right, let's hear the argument on the other side. Who believes that the, right next to you, wonderful, we got to, as long as you remain civil after the debate, as you will, because this is a civil discussion. Why do you think that the law violates the First Amendment? Another mic. Mics are important. Here we go. Wait, just one second.
I'm Sydney from Eastern, same as Elijah. I think that, yes, they want to discipline us that way, and I know we have less rights in schools, but at the same time, like, we don't have a uniform school, but yet if we break the dress code so many times, we get suspended for that. So if it's like, if dress code is a distraction in class, why is our own free speech a distraction for the class? And we should be in a place where we can openly argue and question other people's views in order to get our views and learn from that.
Great, that's a very powerful example. You're saying already you're subject to all sorts of kind of arbitrary disciplinary things. If you just break the dress code 3 times, then you get discipline. And that gives school administrators a lot of discretion to discipline you if they don't like your expression, they can use the dress code or some other violation and violate your rights of free speech. And in fact, the people who are arguing against the Kentucky law say that it is being used discriminatorily against Muslim students, Latino students, African American students, disabled students, basically school administrators who don't like particular groups or they don't like their behavior are making up these arbitrary disciplinary rules using these vague standards to suppress speech. Great, so this has been a very substantial constitutional discussion. We could go on for a lot longer, and there's a lot more to say, and there are a lot more cases, but already we've teed up the issue, we've acknowledged that there are decent arguments on both sides, we have heard them, and we've engaged in the highest thing we can do as citizens, which is to engage in civil dialogue about the meaning of this central document of human freedom that unites us. And we didn't even bring politics into it. We just focused on the Constitution. All right, you can see why I'm so incredibly fired up about this mission that I have to promote constitutional conversations across the country. And this is my challenge to you. It's very important that you accept it. I hope you will accept it, and that you think with me about how best to promote conversations among classrooms. So you could, if you accept the challenge, just have two teams having one of these conversations, and they could be moderated by a judge, and the Constitution Center could help you find someone, or you could find another trusted moderator. I can assure you that anyone in town, the mayor of Louisville, you'd get Congress people who would want to moderate this kind of debate if you approach them in the right way. Or you could use this new platform that the Constitution Center is just launching that allow virtual constitutional exchanges, allowing classrooms from different states to sign up online and in real time, face-to-face, to have these conversations moderated by a judge or a master teacher. Or you could decide that you want to connect with a classroom in a different part of the state or even in a different state and use the virtual technology or figure out some other way to do it. I'm leaving the challenge up to you because I really need to figure out how best to promote these conversations so that classrooms, starting in Louisville and then spreading across America, can educate themselves and have these crucial conversations. We launched these exchanges a year ago and have had 50 classrooms representing about 1,200 students, and they're thrilling to watch. It is so exciting to see classrooms from Pennsylvania to California, and we did have some Kentucky classrooms connecting with some in Michigan, and they're about a half hour, and they're moderated by a judge, and they're really inspiring. So I want, the challenge is first you figure out how you want to have the conversation, connecting one classroom, your group, with another, somewhere else in the community or the state or the country. And the second thing you've got to do is pick the topic. I just came up with this Kentucky law because a friend who I met last night, who is one of your colleagues in the school district, called my attention to this Kentucky law. It took about a second of Googling. You might want another topic that's in the news, or you might want to talk about a different amendment like the Second Amendment. And we could have just as lively a discussion about the Second Amendment as we do about the First Amendment. And I can't resist telling you that the Supreme Court just 3 weeks ago, if you think this topic isn't exciting enough, agreed to hear the first major Second Amendment case is heard since 2010. It was almost 10 years ago in the McDonald case that the Supreme Court struck down a Chicago law that had a total ban on gun possession in the home. That followed the Heller case from a few years earlier, which was a similar DC law that was a total ban on gun possession in the home. The Supreme Court said that these two laws, which were the most extreme bans on gun possessions in the home in the country, violated the Second Amendment, which says, I don't know, we could try to do it by heart, but let's take out the thrilling interactive Constitution app and read the text. No cell phones. Here it is. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, there's so much to unpack in this text, and obviously there's a lot of debate on the Supreme Court and in the country about what does it mean to have a well-regulated militia, and was the amendment only designed to protect citizens who were organized in militias, or was it intended to protect an individual right of self-defense? Now, you can't just look at the text that was adopted. It's also helpful to look at the text that James Madison and the other framers drew on when they wrote the Second Amendment. And that's another amazing thing you can do on this interactive Constitution app. I'm like a Ginsu knife salesman of the Constitution. You can go and you can click on all of the Revolutionary era state constitutions that Madison drew on when he wrote the Second Amendment. And if you do that, you'll find that 2 states, Vermont and Pennsylvania, explicitly protected a right of the people to bear arms for the defense of themselves or for purposes of killing game, sort of an individual right of self-defense, whereas all the other 11 states talked about the rights of citizens organized in militias to defend themselves against federal tyranny, in particular against standing armies that were trying to take away their arms. The central concern that the framers have, we learned from the interactive Constitution scholars, is they were really scared that a tyrannical federal government is going to take away the people's liberty. So they wanted to allow the people organized in their state militias to defend their rights in their states and prevent the government from taking away their liberty. And the main thing they disagreed about was whether or not an armed people would be adequate to deter federal oppression. So they were not thinking about assault weapons. They weren't thinking about background checks. They were thinking about the king coming and taking away the people's rights. So all of the hard questions before the Supreme Court today can't be answered by the history. You've got to look at precedent. You have to think about translating the framers' values. But the case the Supreme Court just agreed to hear is the first case involving not a total ban on gun possession in the home, but the right to carry guns outside the home. And New York State has a law that prohibits you from carrying your lawful gun, which you own in the home, anywhere outside except to a licensed artillery range. So it's a pretty extreme law. And a lot of people won't be surprised if the Supreme Court strikes it down just because not a lot of other states have bans on carrying guns outside the home that are as extreme as New York. That doesn't mean that the laws that are really contentious, many of which have been passed since the Parkland shootings, will be called into question. The Supreme Court has already said that guns prohibiting carriage in school are permissible. The Supreme Court said those are fine. They said background checks are fine. They said banning guns for the mentally challenged are okay. So a lot of the action when it comes to the Second Amendment is going to come from legislatures. And some states have passed laws explicitly allowing people who are 18 years old to carry guns in schools, and others have banned guns in schools, and so far either of those are okay according to what the Supreme Court has said so far. So the Second Amendment question is really complicated. And if you approach it not, I like guns, I don't like guns, I think guns are a huge public health concern, as many people do, or I think that it's really important to carry arms, which many people do, but instead, what does the Second Amendment allow or prohibit? We would need a lot more than, wherever the timer is, than the 2 minutes we got left to have that conversation. But that would be such a fascinating conversation to have, and it would be wonderful if your group chooses, as part of your challenge, to debate whether or not the Second Amendment prohibits that New York law prohibiting carriage outside the home, or prohibits assault weapons bans. Many states courts have upheld assault weapons bans so far. There are good arguments for and against those. You could do that as well. So you see how excited I am about this challenge and how the future of the Republic depends on your accepting this challenge, because we must find a way of your connecting with other groups in your community and debating these crucial constitutional questions. We have just time for, I think, 1 or 2 questions about the challenge or about anything else. Yes? Oh, sorry.
I'm Lee Henry from the Brown School, and I was going to ask you how you think that the general level of understanding of the Constitution and the government in general among youth has changed over the past decade or even just the past 3 years.
The statistics are alarming. Justices Sotomayor and Neil Gorsuch have both noted that only a third of Americans can name all 3 branches of government, and a third can not name a single branch of government. And those numbers are going down. They're at their lowest levels recently. A majority of students think that the First Amendment allows the banning of hate speech, even though the Supreme Court has said that it doesn't. And the levels of civic knowledge are alarming. Everyone around the country is lamenting it, but it's up to you, to us together, to figure out a way to solve this. We have all this amazing online material on this app, but you got to figure out a way to engage your colleagues in discussions about this so that we can educate America. It is extremely important. Yes?
Hi, I'm Michaela, once again. Hello.
Hi.
So I did have a question pertaining to the Kentucky case. Will you say that it correlates with the pipeline involving the discrimination between black and white kids, whether who gets a slap on the hand and who either gets to pay that $500 fine or who will be expelled or suspended from school?
It's a great question. I read the brief filed before the Supreme Court by the Student Press Center, and I don't know how quickly I can find it, but they have a paragraph in there saying that the Kentucky law in particular and these disruption laws in general are disproportionately applied against minorities, and they actually give examples. So if you Google the Ed Week article about the Supreme Court's decision not to hear the case, there's a link to the brief, and you will find it. Here's another great thing, and this is part of my challenge too. You must read the briefs and the opinions. It is really important. Don't believe that these are just for lawyers. There's a lot of legal technicalities in them. Don't be intimidated by it. The basic principles that the student press people are discussing are, is the law being applied in a discriminatory way? So read the primary documents, read the briefs on both sides, and then you'll find the citations and you can go and verify them. Read the Supreme Court opinions, both the majority opinions and the dissents. It's very important that you recognize that there are good arguments on both sides. Now, some of these opinions are really long, like 70 pages. You can skim them. The virtue of skimming, intelligent skimming, will allow you to distill the nub of the issue. This is what great law students do, and I know you can do it. I have faith that you have the ability to absorb this complicated and important material. So it's very exciting to go back to the primary sources. If you take the Kentucky case, read the briefs on both sides, read the Kentucky court's opinion, read the Arizona and North Carolina decisions upholding similar laws, and then you can really make up your own minds. One last question, I think. Yes? Yeah. Oh, two? Okay, well, if we can get away with it.
My name's Kate Sorden, and I'm from Butler Traditional High School. I was wondering how this Kentucky law will affect those students that sit down during the pledge.
Wow, that is such a great question, and that would be a crucial question for you to debate if you accept my challenge, which I very much hope you will. The sitting down during the pledge cases, well, actually, I'll throw this back to you. Do you believe that the First Amendment allows you to sit down during the pledge? Yes, and I can say confidently you're correct. It does allow you to sit down during the pledge because in another of the most beautiful Supreme Court opinions in the 20th century, anyone know the pledge case? West Virginia versus Barnett. It was a group of Jehovah's Witnesses, kids in World War II, 1942 or so, who didn't want to say the pledge because it violated their prohibition on oath-taking. And the Supreme Court upheld their right not to take the pledge. And here are Justice Robert Jackson's beautiful words. Like Louis Brandeis, Jackson was a gorgeous writer, and his words have a kind of constitutional poetry. He said, if there's any fixed star in our constitutional constellation, it is that no official, high or petty, shall decree what may be orthodox in matters of conscience and speech. It's so beautiful and true. So you absolutely do not have to stand for the pledge, and if your teachers try to make you do it, say the First Amendment says I don't have to. But there are really hard questions about whether NFL players can take the knee. Why is that? The NFL is not the government. It's a private organization and is taking a knee during a game the same as not saying the pledge. These are tough questions, and it would be really exciting for your class if you decide to do a First Amendment question to ask precisely what you just said. What would the implications of upholding? That's such a great question, and that's exactly what the people who are opposing the law say. What would the implications of upholding the law be for restricting student protest or speech in other contexts? Wonderful. I think, please, yeah.
I'm Essence Yates, and I attend Butler Traditional High School. And as in our school, we wear uniform, khakis, and maybe a Butler sweatshirt. But the thing is, we do have dress down days. And yes, we have a lot of LGBTQ kids that go to our school, but they don't express themselves. But let's say they're sitting in class and they wear like we dress out one day and one of them wear a rainbow shirt. What if the teacher did not approve of that? What would that be for them?
That's such a great question. I don't know the answer. I mean, there must be a whole bunch of these cases coming up, I bet, all over the country, where students are trying to express themselves. These clash with dress code policies, and I just don't know, because I haven't looked into it, what lower courts have said about that. So that's what makes the topic so interesting. And again, asking whether this Kentucky disruption law might make it easier for school administrators to forbid an LGBT student from wearing a rainbow shirt would be really crucial as well. What's so exciting about these conversations, I teach constitutional law. You can tell I'm very enthusiastic about the Constitution. And I know about some of the cases that have been decided in the past, but all the exciting questions that are affecting your lives, that are in front of us every day, are all open questions. It's like this beautiful canvas where none of us, whether we teach the Constitution or just beginning to study it, can have an informed opinion unless we dig in and study the cases. So I really want you not to go in with an open mind. Don't assume that you know the answer to any of these questions until you've studied the case law, the text, you've thought about how one principle will apply in other cases, and always open your minds and your hearts to the arguments on the other side. Don't assume that the people you disagree with are bad people or motivated by wickedness, but recognize that there are decent arguments on both sides of these hard constitutional questions, and that by itself is an act of civic empathy, which the framers of the Constitution thought was necessary for the Republic to survive. I'm going to end with this. This is going to sound a little earnest, but I believe it, so I'm going to tell you this. James Madison and the other framers thought that unless students like you educated themselves about the science of government and about the principles of the Constitution, then America would go the way of Greece and Rome. Madison studied failed democracies, which had given way to demagogues and the mob. He believed that a people unfamiliar with the structures of government might surrender their liberties to people who would mislead them for their own purposes. And that's why he would be alarmed by studies suggesting that some young people today are willing to abandon our constitutional system and accept more authoritarian ones. So I believe that unless you accept my challenge and help each other come up with ways of having these civil conversations about these crucial constitutional issues at the center of American life, then the future of the American Republic will falter. However, if you accept the challenge, and I have faith that you will, you can help elevate America and have Louisville serve as a beacon of constitutional light that will inspire thousands of other students in classrooms across the country, not to polarize and separate, but to connect and converse so that together we can explore areas of agreement and disagreement about this beautiful, meaningful, crucially important document of human freedom which unites us, the U.S. Constitution. Thank you so much.